whether you wear a badge or not. If you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report. Hello, and welcome back. I'm glad you're here. If this is your first time joining me, here's what this show is. The Conditions Report is a weekly series where we read the skies of policing the same way a pilot reads the weather. Every episode follows the same structure. We're going to start with the statutory climate. That's the constitutional and statutory baseline you operate inside. Then we'll move to the legal front, where the real cases stress test the rules and show you the edges. And after that, we'll shift into the leadership climate. That's the maxim that you can carry into the field, the locker room, and the briefing room when it actually matters. And we finish with an extended forecast, which is a practical week-ahead application that you can use on the street tonight. The idea behind this show is simple. Policing is an environment, and that environment changes fast. The legal and cultural atmosphere move. If you cannot read the sky, you will get caught in the storm. The goal here is clarity. We see the system, understand the rules, make decisions that stand up inside the courtroom and inside the community. The Conditions Report is part of The Forecast, a project by Forecast Securities Group, LLC, the training and consulting company I founded. We help professionals in high-risk environments operate with legality, precision, and clarity. Before we begin, the disclaimer. This presentation is for educational purposes only. It is not legal advice. I'm not an attorney, nor am I acting as one, and I do not represent any agency, department, or government entity. I speak only for Forecast Securities Group, LLC. If you're dealing with an actual case, consult a qualified attorney. All right, let's get into it. Tonight's episode is called The Dichotomy of Silence. We're going to the origin point of modern interrogation law. We're going to Miranda, not the television version, but the actual case, the lineage that led up to it, and what courts held, and what came after. We're also going to the strange and uncomfortable irony at the end of Ernesto Miranda's life. A suspect in his killing was detained, read the warning that bears Miranda's name, invoked the right to remain silent, and no one was ever convicted. And that is the dichotomy. The same silence that protects the innocent can also shield the guilty. All right, let's start with the statutory climate. We're going to go all the way back to the foundation, where every interrogation, every recorded statement, and every courtroom argument begins. The Fifth Amendment, which reads, "No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law." That line is the heartbeat of what would become the Miranda Rule. It's not about comfort. It is about compulsion. The government cannot force a person to build a case against himself. The Sixth Amendment says, "In all criminal prosecution, the accused shall enjoy the right to have assistance of counsel for his defense." That right is not a courtesy or a favor. It is a safeguard that stands between the power of the state and the vulnerability of a person under pressure. The 14th Amendment made both of these rights apply to the states. It says, "No state shall deprive any person of life, liberty, or property without due process of law." And that phrase, due process, ties every local officer in America to the same federal boundary. When you're questioning somebody in custody, you're operating inside that constitutional space, whether you think about it or not. Before Miranda, there was no script or standard warning. Courts looked backwards after a confession and asked one simple question. Was it voluntary? That single word, voluntary, carried the weight of the entire trial. Judges decided the answer after the fact, often years later, based on memory, notes, or testimony, because quote-unquote voluntary was undefined. Departments filled in the blanks on their own. In Brown v. Mississippi, 1936, deputies tortured 3 black men until they confessed to a murder. The Supreme Court ruled that the confession extracted by violence are not evidence at all, but extortion. The decision ended the beatings, but it did not end the physiological or psychological pressure. In Ashcroft v. Tennessee, 1944, police kept the man awake for 36 straight hours of questioning. The court ruled that exhaustion is a form of coercion. When fatigue breaks the will, it destroys the voluntariness of a statement. In Spano v. New York, 1959, detectives used a suspect's childhood friend, a rookie police officer, to persuade him to confess, and the court ruled that friendship used as leverage is still coercion. Each of these cases defined coercion a little more clearly, but the rule was still uncertain. What was coercion to one judge might not be to another. Then came Messiah v. United States, 1964. Once formal charges are filed, the government cannot deliberately question a defendant without counsel. The Sixth Amendment right to counsel had officially been attached. That same year, Escobedo v. Illinois, 1964 as well, moved the line even closer to the moment of arrest. Danny Escobedo was arrested for a murder, questioned for hours, and then denied access to his lawyer, even after asking for one repeatedly. The Supreme Court overturned his conviction, holding that once an investigation focuses on specific suspects who are in custody, denying a request for counsel violates the Constitution. Still, there was still no national procedure, no operational checklist, and each case was decided after the fact. Some officers gave warnings, others did not. Every suppression hearing became a credibility battle about who said what and when. That all changed in 1966 with Miranda v. Arizona. The court created a single, repeatable safeguard. It's not a new right, but a practical way to give life to an old one. That brings us to the legal front. Miranda v. Arizona, 1966, is actually 4 consolidated cases. Miranda v. Arizona, Vignera v. New York, Westover v. United States, and California v. Stewart. The facts are all different, but the core problem is the same. A suspect is in custody and is being interrogated by the police. No standardized warning and no counsel. Ernesto Miranda was a 23-year-old factory worker in Phoenix, limited education and prior contacts with the system. Police questioned him in a station house room for about 2 hours. No physical abuse, no threats, and no lawyer. No advisement of rights. Miranda signed a confession on a form that included a short line stating that the statement was, quote-unquote, voluntary. At trial, that paper was the spine of the case, and he was convicted. The Supreme Court, though, through Chief Justice Earl Warren, held that custodial interrogation is inherently coercive. The Fifth Amendment right against compelled self-incrimination requires procedural safeguards that are effective in practice, not only in theory. The court created a clear rule. Before custodial interrogation, officers must advise the person the following. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish. And after the warning, the government bears the burden to show a valid waiver. The waiver must be voluntary. It must be knowing. It must be intelligent. And the court did not require specific script word for word, but it did require substance that covers the core right. The court did not say an attorney must be present for all questioning. It said that the suspect must be told the right exists, and if the suspect invokes the right to silence or counsel, the police must honor it. 2 terms became operational anchors: custody and interrogation. Custody means the formal arrest or restraint on freedom of movement to a degree associated with a formal arrest. And interrogation means the express questioning or its functional equivalent. That includes words or actions that the police should know are reasonably likely to elicit an incriminating response. You'll hear these words again when we talk about later cases. The dissent warned that the new rule would quote-unquote handicap law enforcement, that the majority answered with a single idea: the Constitution must come first. If we value the Fifth Amendment, we must give it a practical effect where the pressure is the highest. From that day forward, every cop in America carried a rule inside their pocket: a card, a script, and a burden. Give the warning when the person is in custody and you want to interrogate. Secure a waiver. If the person invokes, stop as the law requires. That's the law. Now we're going to tighten the definitions and add a case that gives you fine control. The post-Miranda evolution. what custody looks like. The question is not what you feel. The question is whether a reasonable person in a suspect's position would feel free to end an encounter and leave. Berkmeyer v. McCarthy held that ordinary roadside traffic stops are not usually custody. Brief, public, and limited in scope, the same officer can make a roadside stop custodial if the scope becomes a de facto arrest. Duration, tone, location, number of officers, and restraints all matter. Custody inside of a prison is not automatic either. In Howes v. Fields, it taught us that questioning an inmate is not necessarily custodial. You look at how the interview was conducted, the location, the duration, and what level of restraint. Advisements that can end the interview at any time and age also matter. In JDB v. North Carolina, the court held that a child's age is relevant to the custodial analysis when age is known or obvious to the officer. So what does an interrogation look like? The definition comes from Rhode Island v. Ennis. Interrogation includes express questions and their functional equivalent, words or actions reasonably likely to elicit incriminating statements. Routine booking questions are normally safe because they seek a biographical data. If you know a question is likely to produce an incriminating answer and it becomes interrogation, even if you call it administrative. Invocations and waivers. Once a person clearly invokes the right to counsel, the Edwards v. Arizona rule applies. Do not reinitiate questioning. Wait until counsel is present or there's a valid break in custody. Under Maryland v. Schatzer recognized that a break in custody of at least 14 days can reset the Edwards protection. If the suspect invokes the right to silence, honor it. You can reapproach later if you scrupulously honor the invocation and re-administer warnings. Ambiguity matters. In Davis v. United States, the court held that the request for counsel must be unambiguous. If a person says something like, "I might want a lawyer," that is not a clear invocation. But if the person says, "I want a lawyer and I need them now," that is an invocation and we should treat it like one. Silence alone is not an invocation. In Burgess v. Tompkins, the suspect remained mostly silent for a long period of time. He then answered a crucial question, and the court held that the right must be invoked clearly. If the person chooses to speak after a valid warning and a valid waiver, those statements can be admissible even if there was a long period of silence first. The safer course for the officer, though, is to ask for a clean, explicit waiver from the start. Do you understand these rights? Having these rights in mind, do you wish to talk to me? Capture this yes clearly on audio or video and document it in writing. Warnings, errors, and exceptions. Not every Miranda violation suppresses every form of evidence. In Michigan v. Tucker, the court allowed testimony from a witness discovered because of a Miranda violation, where the officer acted in good faith before the law was settled. In Oregon v. Elstad, recognition that an unwarned but voluntary statement does not necessarily taint a later warned statement if the later waiver is valid and the first error was not coercive. But Missouri v. Siebert drew a hard line against deliberate two-step strategies designed to undermine the warning. Do not try to question first and then warn later to launder a confession. This will likely fail in court. There are narrow exceptions for imminent safety threats, for instance, New York v. Quarles. Officers, if they face an immediate public safety risk like a hidden gun in a supermarket full of people, they can ask limited questions aimed at neutralizing the threat before warnings. But the exception is narrow and fact-specific. It's not a free pass for convenience, and Miranda is not a mere rule of evidence. In Dickerson v. United States, the court reaffirmed that Miranda is a constitutional decision and that Congress cannot overrule it by statute. That case closed the door on the idea of Miranda being optional, because it is not. Civil liability analysis is different. In Chavez v. Martinez, the court held that failure to give Miranda warnings does not itself create a civil damage claim under Section 1983. The statements are not used in a criminal case. Use in a criminal case is the pivotal factor for self-incriminating clauses. And finally, understand the difference between Fifth and Sixth Amendment counsel rights. Miranda safeguards the Fifth Amendment privilege during custodial interrogation, before or after the charges. The Sixth Amendment right to counsel is offense-specific and attaches after formal charges have been filed. After attachment, the government cannot deliberately elicit statements about that charged offense without counsel present. That's Messiah and its progeny. Know which rule you're operating under. That is the doctrinal map. Now, let's come to the human paradox that gives tonight's episode its name: the paradox and the man. Ernesto Miranda's original conviction was reversed because of the confession. It was taken without a valid warning and waiver. He was retried without the confession and was convicted again on other evidence. He served his sentence and was released in 1972. Back in Phoenix, Miranda lived quietly. He drifted between jobs, warehouse work, truck driving, and dishwashing. And sometimes he carried small printed quote-unquote Miranda cards that he sold and autographed copies to curious locals and police for $1 each. The warning that bore his name had become both cultural artifact and a souvenir. On the night of January 31st, 1976, Miranda was at the Amapola Bar, a rough cantina in downtown Phoenix. Around 9:30 p.m., a fight broke out over a card game. Someone pulled a knife, and when officers arrived, Ernesto Miranda was bleeding from a stab wound to the chest. He was pronounced dead shortly after, and he was only 34 years old. Detectives canvassed the area and detained several people. One man suspected of handling the knife and giving it to the killer was taken to the station. There, officers did exactly what the Supreme Court had required. Because of Ernesto Miranda's own case, they read him his rights. He invoked his right to remain silent and requested an attorney. Lacking a statement, police released him. Another suspect, identified as Ezequiel Moreno Perez, was later charged with Miranda's murder but fled to Mexico before trial and was never apprehended. No one was ever convicted for the killing. And that's the line that matters. The same rule that once invalidated Miranda's confession now protected the men connected to his death. The same safeguard that frustrates investigators shields every citizen from the power of the state. And that is the dichotomy of silence. The Constitution restrains the government when the government believes it has the right person. That restraint is what gives legitimacy to every statement lawfully obtained afterwards. When the safeguards are honored and a suspect waives the right and speaks, jurors can trust what they hear. When the safeguards are ignored, the case may die and the public trust dies with it. That brings us to the leadership climate. No one follows a ghost. Leadership in policing is not a theory. It lives and dies in presence. You cannot command from a distance. You cannot inspire from comfort. Your people will forget every memo and email that you write, but they will remember the nights that you stood beside them when it counted, the weekends and holidays where you were visible. They will remember the tone in your voice when the plans all went bad, but you said slow it down instead of shouting. And when they realized that you were the calm because you've been there before and you brought your experience. That's leadership. It's not charisma, it's credibility. Presence is the proof of belief. When your people see you when it's loud and chaotic and uncertain, they know the words that you say in the daylight mean something in the dark. You earn that faith by being there and by choosing to be in the chaos over the meetings and boardrooms. Colonel David Hackworth, one of the most decorated soldiers in American history, built his reputation leading from the front in Korea and Vietnam. In his memoir, About Face, he wrote that soldiers do not fight for flags or speeches. They fight for the men beside them. That same principle holds true for cops. Policing is no different. Cops do not follow mission statements. They follow trust, they follow competence, and they follow the example. If you're never there, you're nothing but a rumor. If you only appear for inspections and discipline, you're nothing more than a threat. People under you will not fight for a ghost. Presence builds trust. Trust wins fights before they begin, and it keeps teams tight when fear starts to spread. The best leaders don't raise their voice, they lower the temperature. Their calm steadies everybody else's hand. You have to know your people. You have to know their habits, their stress points, their strengths, their weaknesses. The guy who sees the big picture, the guy who gets tunnel vision, the one who talks too much on the radio, and the one who barely speaks but always delivers. Leadership is about not guessing. It's about studying your team until their patterns are second nature to you. Protect them with training and clarity. Give them law and policy until it is part of their reflexes. Do not make them robotic, but make them confident. Confidence under pressure is their armor. Confusion, though, can be fatal. A leader's job is to remove ambiguity. That's what presence does. When they see you, they don't panic. They adjust. When you speak, they listen instead of just noise. You don't have to be everywhere. You just have to be seen where it matters the most, when it's chaotic, not in the safety of the office. So be there, because when the dust rises and the tones ring out, no one follows a ghost. That brings us to our extended forecast. Our operational takeaway for the week. Here's the forecast. The legal weather on interrogation will never go out of style. It will be judged for as long as you carry a badge. You need to do a repeatable process that works in the room and on the record. Number 1, run the 2-key test before you open your mouth. Key 1 is custody. Would a reasonable person in this exact situation feel free to leave? Consider location, duration, numbers, tone, restraints, and age. Key 2 is interrogation. Are you about to ask questions or say things that you should know or know are likely to elicit incriminating responses? If both keys are on, you are in Miranda territory. Warn and give a clean waiver. Number 2, get the waiver right and get it on record. State the warning clearly, confirm comprehension, and ask for the waiver directly. Example, do you understand each of these rights as I explained them? Having these rights in mind, are you willing to talk with me? Record the yes. Use a written waiver or digital form to capture the signature or initials by each right. Photograph the form with the suspect and the case number visible and log it into evidence or interview it on audio and video. Number 3, treat invocations like a red light. If the person says, I want a lawyer, stop. Do not try to talk the person out of it. Don't circle back with new words or the same custody block. If the person says, I don't want to talk right now, stop. Scrupulously honor the invocation. If you're going to reapproach later, rewarn and confirm a new waiver. Document the time, the break, and the reason for the reapproach. If the person raises an ambiguous line, like maybe, I should get a lawyer, get clarity. Ask for neutral clarifying questions. Do you want a lawyer or do you want to continue talking? Document the answer. 4, respect the Schatzer clock. If counsel was invoked, a break in custody of 14 days is a safe harbor for new initiation without counsel. If the person returns to general prison population after a prison-based interview, that can count as a break in custody. Get legal guidance from a prosecutor or your local practice. Document this timeline. Number 5, use the public safety exception only when it's truly about safety. If there's a gun hidden in a public space or an imminent hazard you need to neutralize, then ask narrow questions you need to remove the danger. As soon as the scene is safe, pivot directly back to warnings and a waiver. Keep the safety questioning tight and mission focused. Do not wander. 6, document your interview environment. Photograph the room, document the temperature, the conditions. If it's relevant, describe the restraints or the absence of restraints. Note the number of officers present. Record that a water was offered. Record there were restroom breaks, and small details matter when a judge asks, was the setting coercive? You're building the answers in real time. 7, teach the difference between rapport and pressure. Rapport is a connection. Pressure is leverage. Coercion is compulsion. If you promise results you cannot deliver or threaten consequences you cannot impose, you're stepping towards compulsion. Train scenarios where the interviewer has to back away from the tactic and reset the temperature. Build this skill the way you build room entry discipline. It's the same idea. Control the tempo, control the angles, and control yourself. 8, build a Miranda articulation block into every report template. Add a section with these lines like location of advisement, exact wording used in the agency card, confirmation of comprehension and explicit waiver, timestamps or invocation, if any, breaks in questioning, presence or absence of restraints, the identity of officers present, the content of any clarifying questions about counsel, and create a checklist that you can copy from your template to your report while your memory is fresh. 9, prepare for defense review like it's part of the mission. This will be challenged. The tone, the pace, the word choice, the timing, expect a challenge. You're going to win through clarity, clean warnings, clean waivers, and professional conduct. When you process this in a solid way, jurors will trust you, and because they are going to look at you like you're a disciplined professional. 10, accept the paradox. Sometimes the warning will mean the person does not speak, and sometimes the case will fail. That's not a failure of policing. That is the cost of a free society that puts limits on state power. The same process that stops you from pressing too hard is the process that makes your good cases unbreakable. It's the price of legitimacy and the shield that protects every honest confession that you ever take. So, let's talk about field language that you can use tonight. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to the presence of an attorney before and during questioning, and if you cannot afford an attorney, one will be appointed to represent you before any questioning if you wish. Having these rights in mind, do you want to talk to me? If the person invokes, acknowledge. I hear you. We're going to stop questioning. If you change your mind and want to talk to me later, with or without a lawyer, you can let me know. For now, we're done. Keep it clean, respectful, and on video. Document it in your report. The lesson tonight is not that Miranda made your job harder. The lesson is that Miranda made your job cleaner. When you operate inside this rule, you protect the case, the community, and yourself. The Constitution is not your opponent. The Constitution is the boundary that gives your work the legitimacy it deserves. The dichotomy of silence is real. The warning can help a guilty person avoid conviction, but it can also prevent an innocent person from being ground down by pressure. Accept that tension and choose discipline over shortcuts. Your best cases improve. Your worst cases never start. Be deliberate, be measured, speak clearly, respect the invocation, and earn the waiver. Build the record. I'm Don, and this has been the Conditions Report, Episode 5, The Dichotomy of Silence. Be the calm in the storm, the clarity in the confusion, and always influence the weather. We'll see you guys next week.